Welcome to Judge Today. Will justice prevail today? Let's find out. Stay with us as this courtroom case takes an unexpected turn.
A little early, but I think the parties are present, so call the next case, which is Abigail Hornstra, Jamie Brown, file 23-19492-DP. Do see Mr. Brown is present. Here's Ms. Hornstra is present as well. Looks like this is an objection to the referee's recommended order. Mr. Brown, this is your objection. Why don't you state your reasons and what you're asking the court to do?
I'm asking for everything to go back to how visitations were before, because I do not see any reason for any change.
Did you show up for the referee hearing?
No, there was a apparent. I had everything in a big file, and then I accidentally missed the time. I did still show up, but it was not on time.
So did you get a chance to offer evidence and make your arguments in front of the referee?
No.
Well, an appeal, which is what you've done, has the right to have me look at it with fresh eyes, but that doesn't necessarily mean that you have the right to present new evidence that you could have presented at the last hearing. What you told me is you messed up and missed the hearing, but it doesn't seem to me like there's a valid reason for doing that. So all I would be doing is looking at what was presented to the referee that Ms. Hornstra already presented, and deciding whether or not the referee made an error of law, or whether I think that there's some valid reason for changing what was done. And in general, that's not likely to happen. I suppose it could, but it's not likely to. Why do you believe that there was an error made other than you don't like the outcome?
Because I have missed a lot of time with my daughter Emberlyn because of it, and it is going to end up ruining mine and her relationship. There was no facts or actual evidence
from you, but I believe that she presented facts and evidence to the referee, and that's why he made it says after I'm reading from the referee's recommendation. It says after testimony from the plaintiff, so facts and evidence were presented to the referee. He then reviewed the factors for proper cause and change of circumstances and went through the best interest factors for the Michigan child custody case. He then made a decision that you would have joint legal custody. She would have primary physical custody. And you would have supervised parenting time every other Saturday. And then on Sunday as well, holidays as the parties agree, and additional parenting time as the parties agree, with the option of being unsupervised. So how is that preventing you from having a relationship with your daughter?
Because there's only certain amounts of time that I'm allowed to have with them, and with both of my daughters, with Emberlyn and Athena, and it really ruins the time that they have together and with me.
Your legal argument is that you do not agree with the proper cause or change of circumstances. What do you disagree with about the referee finding that there was a proper cause to change the custody and parenting time?
I believe that there was no proper cause.
I understand that, but what do you disagree with in his determination? What facts? You're telling me your conclusion. You're telling me a conclusion. What are the facts by which you believe that there was no cause to change it or basis to change custody?
That it was just over all hearsay, basically.
If you weren't there, how do you know it was hearsay?
I don't exactly. I just know what she said she was going to say, Your Honor.
All right. Anything else that you want me to know, Mr. Brown?
Not that I'm aware of at this second.
All right, Ms. Hornstra, is there anything that you want me to be aware of?
There's actually quite a few things. Like it says, he has supervised visitation. When he does come to said supervised visitation, he's been taking maybe 3-4 hours and sitting on his phone. I have cameras in my house that can document that.
Okay, hang on a second. Today is not about what he's been doing since the court order. Today is only whether or not I should, for some reason, change what the referee did at the time that the referee made that decision. So the only thing I'm going to look at, what I'm likely going to do is review the video of the referee hearing. So the only thing that I'm going to hear from you today is what happened at the referee hearing, and anything different that he hasn't told me already.
Not really. He's had no contact with his daughter for 3 weeks, so I don't think there's any need to change anything.
All right. What was the reason that you gave to the referee to want to change custody at the referee?
Our daughter, who is going to be 3 next month, has came home with 3 black eyes, a bruise on her thigh, a bruise on her shoulder. I had to take her in for an abuse report. And then my daughter also came home saying Jimmy's wife hit her in the eye with a spoon. So I am very, very scared for my child's safety, because a 2-year-old just doesn't make that up.
And was that the reason that you gave to the referee to ask for a change of custody?
Yes, because I believe there's some abuse there.
Ma'am.
Nope.
Mr. Brown, any final comments?
That I have had DHS and CPS at my house multiple times for all of these allegations that I have had to deal with, and they have never found any proper cause. I have had
There's a difference in proper causes between what DHS or CPS is looking for and what the referee is looking for. Anything else that you want to tell me?
No, Your Honor.
All right. Well, what I'm going to do then is I'm going to get a copy of the referee's hearing. I'll review that. I'm not going to accept any additional evidence. The court rule doesn't require me to look at new evidence if there was a reason that it wasn't presented at the previous court hearing, or there wasn't an opportunity. So I do find that there was a previous opportunity. Mr. Brown simply missed that opportunity through no fault of the plaintiff, of Ms. Hornstra. So I'm simply going to review with fresh eyes. It's called a de novo review or a new review, but I'll limit it to what was done at that hearing. And then I'll issue a written decision about whether or not it should be overturned or not. And I'll send that out to the parties as quickly as I can.